Alrighty, party peoples of the interwebs, I don't want to jinx it, but when the New York Court of Appeals overturns that ridiculous New York nipple judge Engoron's decision, I'm going to give the internet a big fat
I told you so.
Viva Fry, former Montreal litigator turned current Florida rumbler in my home office, and I'm catching up on the oral arguments that were presented to the New York Court of Appeal about 2 weeks ago in the ridiculous New York nipple judge Engoron, Attorney General Tish James' New York persecution of Donald Trump, in which Donald Trump was ordered to pay disgorgements totaling $454 million in penalties and interest. And I said, this is a ridiculous case. There's no victim, there's no fraud, there's no complainant, and it's only a ridiculous political persecution by Letitia James, who campaigned off prosecuting Donald Trump, and her original theory was that Donald Trump has to be laundering foreign money because domestic banks weren't lending to him, and then when she discovered that domestic banks were lending to him, she then had to pivot to, oh well, I guess they're lending to him on the basis of fraud. It was ridiculous beginning to end. And for those of you who may not know why I am referring to Judge Arthur Engoron as New York nipple judge Engoron, that's because Engoron runs an alumni webpage where he posts his greatest hits of orders that he issued against Eric Trump, all these other ridiculous things showing his bias. And at one point in time, he showed a bonus torso pic of his unclothed upper half as if to show that he's in good shape for an 80-year-old, which he might be, but it's wildly inappropriate to share topless photos with an alumni page that probably includes teenagers on it. But New York nipple judge Engoron is not just a weirdo and a pervert for sharing topless photos with his alumni page, he's also a political hack. And if you haven't seen this video, which I shared a dozen times, this is him giving a speech to some prospective journalists over a decade ago, in which he describes all of the tools that he has as a judge to get to the judicial results that he wants.
I had one last thing to say about tools. A lot of what I do involves motions, these summary judgment motions I mentioned. And all right, am I following the law or am I making law? Okay, I'm following law. I'm an impartial referee. But it's hard to factor out my own emotions. And I have tools. Somebody can say, well, Your Honor, you have to throw out this case because it's just like another case. Well, is it just like another case? What if the defendant was wearing a red sweater instead of a blue sweater? Well, that's an extreme example. That wouldn't distinguish most cases, but there are other facts that do. Maybe the education of somebody who supposedly entered into a contract would decide whether the contract was binding. I have a tool that I'll call a tool called estoppel. Somebody makes an argument and I say, you can't make that argument. You made a different argument 3 months ago in this case, or even in another case. So I wish you all luck. I'll stand here or around afterwards for questions. And again, thanks to the administration for having me.
Appreciate what Judge Engoron said right there. He's got a lot of tools, and one of them is summary judgment, which lo and behold, he used and abused of in the context of Letitia James' persecution of Donald Trump. Summary judgments to come to such conclusions as Mar-a-Lago is worth anywhere between $18 and $27 million, despite what the fact checkers said. And we need to back this up a little bit. In that case, New York nipple judge Engoron came to the conclusion of law that Trump's Mar-a-Lago property was worth between $18 and $27 million. It was an absolute outrageous joke at the time. And then you have your wordsmiths of the devil fact checker saying, no, that's factually incorrect. New York nipple judge Engoron did not come to the conclusion that Mar-a-Lago was worth between $18 and $27 million. That's fact checked false. And if you have any doubts about that, here's a fact check from PolitiFact. New York Attorney General Letitia James and Judge Arthur Engoron valued Mar-a-Lago at $18 million. And there you see right there, it says false. If your time is short, New York officials did not determine the value of former President Donald Trump's Mar-a-Lago estate in Florida. The property appraiser in Palm Beach County, where the estate is located, assessed the property and determined its value. In evaluating the property, Palm Beach County officials account for Mar-a-Lago's being a deed-restrictive private club. Unlike a private home, the property's value is determined by the amount of income it generates as a club. So you have PolitiFact saying, fact-check false, Arthur Engoron did not evaluate the property at $18 to $27 million. Ha ha ha, all you MAGA idiots spreading disinformation. And I often refer to fact checkers as the wordsmiths of the devil because that's exactly what they are. If I want to steelman this fact check, they will come to the conclusion that no, it wasn't Arthur Engoron who evaluated the property at $18 to $27 million. It was the county appraiser. Well, that is stupid because Arthur Engoron, as a matter of judicial fact, came to the conclusion when he agreed with that assessment that the property was only worth $18 to $27 million. So yeah, it wasn't Arthur Engoron picking that number out of thin air. It was just Arthur Engoron coming to a judicial matter of fact and agreeing with the appraiser's estimate of the property and not Donald Trump's expert who appraised it at something of $1 billion. So yes, it is factually incorrect to say that Arthur Engoron did not determine that property to be worth $18 to $27 million. And if you don't agree with me, well, why don't you just listen to one of the questions from the judges of the Court of Appeal in that oral hearing?
I want to turn your attention to a different subject because your red light is on. I'm trying to figure out about the valuation of Mar-a-Lago. I noticed that your expert, Mr. Mons, valued it at over $1 billion. He also said that if it was in the hands of a new owner, club memberships, 500 club memberships could be sold, generating $250 million, and it generates revenue of over $50 million a year in 2022 and 2023. And Supreme Court values it at $18 to $27 million because of restrictions. Do you have anything to say about those restrictions taking it down in value to such an extent?
I'd say two things in response to that. First, the Shubin affidavit directly addresses that. That was improperly kind of disregarded.
He says there are no restrictions on it. Shubin says there are no restrictions.
He says you have to interpret, he says the trial court looks at one document in isolation, the deed of conservation. Mr. Shubin says you got to look at all 5 documents, including the historical practice there, to understand what the actual policy is. And for example, they say you couldn't value it as a private residence, but he's been using it as a private residence since 1995, continuously to this day. But the more fundamental point is that valuation, where he relied on a tax assessment, illustrates the hazards to the marketplace as a whole here from having the Supreme Court cite things like Chico Marx in footnote 9 of the summary judgment position, the I know it when I see it standard from obscenity law from Justice Potter Stewart to decide what's a misrepresentation in these statements. When you have expert testimony unrebutted that says these are gap consistent, if we have a system where you can issue perfectly accounting clear and basically statements that comply with gap, and you're held, well, we have another standard. I know it when I see it. That's good. That's bad. People can't do business in real estate.
Now, in those oral arguments, they addressed the statute of limitations, which we're going to gloss over because even if some of the claims are time barred, others are not. So it's not going to be a determinative factor. That will not get Trump out of that case because in and of itself, there are some claims that would not be time barred, even if there are others that were. But I have been saying it from the beginning. This was a judicial outrage. It was a politically motivated persecution from the get-go. There was no victim. There was no fraud. The bank said we were happy with this transaction. They were repaid in full. The only thing going on right here is Letitia James trying to fulfill a campaign promise to prosecute Donald Trump. And then after this outrageous decision was issued and you had a lot of people saying we are going to pull our money and our business out of this corrupt commie state, New York, now you have the Court of Appeal intervening, and I am 100% certain they're going to overturn this decision. I should actually tamp it down a little bit. I'm about 93% certain they're going to overturn this decision. But like I've been saying from the beginning, overturning this decision is not enough. They need to sanction Judge Engoron. They need to sanction Letitia James. They have turned the judicial system into a joke, into a commie joke. Pull your stuff out of New York. Get the hell out of that state because it's not a state in which you want to live or do business. And if you think I'm exaggerating as to how bad this went for the state in the context of these oral arguments, my goodness, just listen here. They cut the lawyer off when she's introducing herself to ask her one of the most difficult yet obvious questions of this entire bogus case.
May it please the court, Judith Vale for the New York Attorney General's office. All of the defendants repeatedly violated...
Ms. Vale, can you identify any previous case in which the Attorney General sued under Executive Law 6312 to upset a private business transaction that was between equally sophisticated partners where the supposed victim had the ability and legal obligation to discover the allegedly misrepresented matters by conducting its own due diligence, where the supposed wrongdoer advised the supposed victim through written disclaimers to conduct its own due diligence and to draw its own conclusions, where the alleged misrepresentation almost entirely concerned inherently subjective valuations of properties and businesses.
Yes.
And where and where the victim never complained about any fraud in the transaction or losses from it. Because I've gone through the cases which you've cited, and all of them always involved a consumer protection aspect. It involved protection of the market.
Several responses.
And I want to add to his question, and little to no impact on the public marketplace.
So the Court of Appeals is going to overturn New York nipple judge Engoron's ridiculous ruling in this case, if only to preserve business and the business opportunities of New York. But overturning it is not enough. They need to sanction Engoron. The question is, when are they going to overturn this decision? Are they going to wait until after the election, or are they going to issue their ruling before the election? I think we're getting a little too close to the election for the court to issue that ruling now. So they're going to wait and issue it when it's not politically inopportune for them to do so, i.e. after the election, because they don't want to interfere with the election, even though by not issuing this decision before the election, they're interfering with the election. And stop, if you haven't already done it, make sure that you have notifications turned on, that you are subscribed to my channel. Drop a comment in the comment section below. We're going to talk about this tonight with Robert Barnes during our Sunday Night Law extravaganza, but it's getting kind of hot in this car. So I'm going to go now, try to finish up some homework before tonight's show. But everybody, most importantly, exercise, eat healthy, get some sunlight, talk to people in real life. And if you want to support the channel, vivafry.com. You can get some great merch, vivabarneslaw.locals.com, for the best above average law community out there. And that's about it. Now you know your vlog. Peace out, peeps. Booyah!
In addition to that, the Office of Attorney General will continue to follow the money, because we believe that he's engaged in a pattern and practice of money laundering the money from foreign governments here in New York State, and particularly related to his real estate holdings.